Welcome to our March webinar entitled Protect Your Pot of Gold. We've done this theme before, of course, it's St. Patrick's Month, and we'll be carrying through the same theme for this year and probably next year as well. Before we get started, like always, though, I'm going to give another minute or two for people to join, and then we'll get started. All right, so give it just a moment, please. All right, so again, protect your pot of gold. We will be talking today about asset protection. We will be talking about how to do that and why to do that. A very common theme as well for our type of work. At the Tully Law Group, we help families undertake, of course, their planning, their asset protection and income protection concerns, but also deal with their care needs. And while today's webinar does not get into the care needs so much, we'll be talking about planning and protecting. Okay, so to get started, what we've got, all right, is a discussion first of what are we protecting from, right? What are the risks? And we have a new one in here today for those folks that have joined us on prior ones. Hold on one sec. Yes. Okay, good. So what we're looking at is what are we protecting from? So today we're going to be talking about four different risks, four different issues that we as adults should be protecting against. And the first one, of course, is going to be any type of long-term care concerns that we have. This refers to aging, it refers to mom and dad, it refers to us and our spouses. And as we get older, we can have different needs, medical needs and long-term care needs. And when it comes to long-term care needs, which we will talk about a little bit, we want to protect our assets in advance of actually having those needs arise. The next concern for many families, and literally this is for every adult, we want to protect against what's called a guardianship proceeding. That is when somebody loses capacity and mental capacity and has not planned in advance to have a backup decision maker. Okay, so we'll be talking about that. And of course, in the theme, the title of today's webinar is Protect Your Pot of Gold, Trusts and Powers of Attorney. So that's how we're going to be solving these problems. The probate proceeding, it is a court proceeding, much like guardianship, where if somebody passes on with certain assets in their name solely, the family must endure a probate proceeding. We'll be talking about that a little bit and how to avoid it, all right, which will help protect your family, protect your time, protect your money, and protect your privacy. We'll also be talking about inheritance issues, all right? So the reality is that people think I need to have a will. I need to get that in place. Well, planning and protection is a heck of a lot more than just having a will in place. In addition, it's also more than just leaving assets to your kids, regardless of their age, regardless of their health or their behavior or their marriage circumstances. We want to protect our inheritances for our children and grandchildren. So we'll get into that a little bit as well today. All right, so how do we protect? And you know, because you're here listening to my webinar, we're going to be talking about trusts and we're going to be talking about powers of attorney. Two very, very important tools. The irrevocable trust is the best, most flexible and comprehensive asset protection tool we have. And the power of attorney is the best and most flexible and comprehensive estate planning tool that we have. All right, so we're covering both of those today. And I hope you like our little shamrocks and leprechauns throughout the day. So yes, we're talking about assets. Yes, we're talking about inheritances. We're talking about courts. We're talking about hearings. We're talking about financial accounts and protecting them. And 100% that is what today is about. But that is not all that we at Tully Law are about. We are an elder care law firm, and that means it is more, what we do is more than just the asset protection and the legal paperwork, what I call the documents and the dollars. We are more than that. We are an elder care law firm, and that means that we focus just as much on the care issues for you and your loved one as we do on protecting the house, if you will. All right, so it's more than just the documents and the dollars. It's about what's inside the house that we also care about. Okay, so I always like to share that because not every elder law firm is the same. Some are different and some are more comprehensive and some are better. So to talk about the first risk that we're protecting against, this idea of long-term care. So what exactly is long-term care? Well, in it is generally accepted that long-term care is something that is when we have needs that are not medical in nature. Let me explain it that way. So we may go to a doctor, we may go to a hospital or a rehabilitation center. Though all of those generally are going to be medical care, okay, medical care, doctors and nurses, etc. When we have medical care needs, that's going to be our medical insurance, whether it's Medicare or what have you. On the other hand, though, we can have needs that are not medical in nature. They can be functional. They can be what can we do, what can't we do? And that is what's up on the screen right now. That is our activities of daily living. For example, an ADL, or an activity of daily living, is literally what we do every morning, all right, in an ideal circumstance. We get out of bed. That's called transferring, okay? We walk to the bathroom. We toilet. We bathe. We groom. We dress, and we eat. Those are generally accepted as the activities of daily living. And if we need assistance with those ADLs, guess what? They're not medical. Somebody coming in to help you walk is chronic or custodial care, or what we call long-term care. So long-term care is when we need assistance with those ADLs. Now, it can also be, oh, there's your walker. Sorry, I meant to have that up there earlier. It could also be the instrumental activities of daily living. Instrumental means that it is not, right? It is not the actual ADLs themselves. It is more of the cognitive concerns, such as driving, shopping, paying your bills, housekeeping, cleaning, preparing food, preparing your medications. Those are the IADLs. And if you need assistance with those, yes, it is long-term care. Sometimes a loved one has just the physical decline with the ADLs. Sometimes we're dealing with more of a cognitive decline, such as a dementia or an Alzheimer's. That's the IADLs. Okay, so when somebody needs help with those, we can have an aide come into the house. It's what's called home care. Okay, home care is the least expensive, generally speaking, when it comes to long-term care. In addition, it's where people want to be. It's what we, as an elder care firm, really strive to have our clients do, is to stay at home as long as it's safe and as long as it's possible. And when I say safe, I don't just mean the client, the elder needing the assistance. I also mean the spouse. It's not always just about the person in need of care. It's also about the caregivers, not equally, but it is a concern and definitely a factor in making decisions. But home care, if a personal care aide was to come into the home, generally speaking, you're looking at about $25 to $30 an hour out of pocket, okay? And you can certainly pay for that care out of pocket, or you can put in your claim for your long-term care insurance if you, in fact, are fortunate enough to have long-term care insurance with the proper benefits, all right? But again, home care, 25 to 30 bucks an hour. Some are going to be a little less, some are going to be a bit more. There's also what's called a companion agency. That is generally a little bit less than a home care agency. Companion agencies are different than home care. Home care, again, is assisting with the ADLs. The companion agency is not. On a daily level, home care can get outrageously expensive, and just wait for monthly and annual. You're in the $300 range for a daily attendant to assist, generally 24/7, okay? Monthly range, just times it out by 30. Now, you're looking anywhere from $9,000 to $11,000, $12,000 per month for home care. Annually, you're over $100,000 for home care. So yes, you can pay for home care out of pocket. Most people don't want to do that because it is so expensive. Where else can we receive long-term care? Well, we could also receive it in an assisted living facility. You see them on all the corners, definitely serve a purpose. They're definitely beneficial for a lot of folks, but they're not for everybody. But if you find yourself needing an assisted living, wanting an assisted living due to the socialization or the congregate type of living, you're generally $5,000 to $9,000 a month. That's going to be your Bristols, your Atrias, your Sunrises. Amber Court's going to be a little bit lower here on the island. Your Arbors is going to be a little bit lower here on the island, generally speaking. But you look at it annually, again, you're about $100,000. This is just your room and board. It may be help with your medications, but it's not care. The care is on top of that. All right. Again, you can certainly pay it out of pocket. Sell your house, use the money for that. That is perfectly fine. You just got to be careful as to what happens when that money runs out. Okay. Third and final place where we can receive long-term care, generally speaking, is in nursing homes. Right. So a skilled nursing facility called a SNF, SNF, is the typical nursing home that you would think of. What you're looking at is up to about some are $700 a day. Yes, annually you're looking about $14,000 to $20,000. Forgive me, a month, and you're over 200 grand, $250,000. Okay, for home care. Forgive me, nursing home care. So the reality is, again, for the third time, you could pay for it privately, but you got to be very careful in the long term because you don't want to burn through every dollar, every account that you have in paying for long-term care. Okay. Now, long-term care, the costs are astronomical. What do folks do? Most of Long Islanders, most of the middle class, we look toward Medicaid to pay for our long-term care needs. We're not here today talking about the details of Medicaid. If you wish to know more about that, of course, you can reach out. You can schedule a free consultation with me, and we'll go through the Medicaid program benefits. We'll get into the eligibility of Medicaid and how that works. But if you can't wait that long, then feel free to go to our website, tulleyelderlaw.com. That's TULLY, elderlaw.com. Under videos, we've got all of our prior webinars over the last 2 years. Or you can go to our YouTube channel, Tully Law Group, and that'll have our recorded webinars up there as well. And in those webinars and YouTube videos, we get into more details about Medicaid. Okay. But in general, for purposes of today, Medicaid eligibility is about three things. It is about a person's assets, it is about a person's income, and it is about a person's care level. And quite honestly, this is why we practice the way we practice. We focus on the care so much because it's one of the requirements in dealing with long-term care. Long-term care is not just about the documents and the dollars, like I shared in the beginning. It's also making sure your loved one gets the best care possible. All right. So again, we deal with that in talking about asset protection and protecting your pot of gold. How do we protect the assets? And yes, we could even protect the income in some Medicaid circumstances, right? Now, the next risk that we're focusing on is guardianship. And of course, yes, I've spoken about this before because it can be one of the most difficult trials to endure, if you will. A guardianship proceeding is, put it this way, it's an adversarial court proceeding that is needed when your loved one loses mental capacity, and does not have in place a very comprehensive, durable, modified power of attorney. So this is the result of not planning in advance, all right? This is the result of not having all of your ducks in a row and sitting with an experienced elder care attorney to make sure you've got the right power of attorney in place. This will happen if there's a loss of mental capacity and you don't have the right plan. It is an adversarial court proceeding where literally the judge has to declare what's called the alleged incapacitated person incapacitated, literally strip them of their rights to make healthcare decisions and financial decisions. There can be a guardian pointed over your person and your property. Guardian of the person is healthcare decisions. Guardian of the property is financial decisions. You don't want to go here. You don't want this to happen. Very truly, every adult out there, 18 and above, should have the power of attorney I'm going to be talking about in place. I've got 2 kids in college. Guess what? They both have powers of attorney in place just in case. It's for every adult so we can avoid this proceeding. One of the reasons you want to avoid it is the length. All right. You're talking about 7, 8, 9, 10 months of a court proceeding. You want to avoid it because of the what I'm going to suggest is the loss of dignity in having your loved one declared incompetent. You want to avoid it because of the cost factors. You want to avoid it because of the potential dynamic within the family and that erupting in not a pretty way in the courthouse. Speaking of money, though, you can have 4 attorneys involved in one court proceeding. You can have the attorney bringing the proceeding. The judge will appoint an attorney called a court evaluator to investigate and create a report for the judge. You can then have an attorney representing the actual loved one who perhaps is fighting it. And you might even have an attorney for a sibling who's saying, you're not going to be the best guardian. I should be the best guardian. I should be the guardian. So costs can be astronomical. All right. As I shared, the time involved with a guardianship, it's about a year. Okay. So the risk there is significant, and you want to do all you can to avoid it. Another risky endeavor that we talk about every single day here is the idea of probate. Probate is another court proceeding which is required if a person passes away with assets in their name alone. Okay. The alternative to having an asset in your name alone is to having accounts jointly owned, or perhaps with beneficiaries, or within trusts, which is what we're talking about today. The end result is you want to avoid this court proceeding. All right. It's another court proceeding to avoid. Keep things within the family, keep things private. There's a little loss of control and time and expense and stress when you start dealing with the courts. Okay. Probate you want to avoid probate because, again, time. You're looking at about 6 to 8 months. You've got court fees, you've got lawyer fees, complete lack of privacy. Everything filed in the courthouse is open for the public to view. And there are literally companies that go there, requisition the files, and harvest the data. They copy down family, names, addresses, what are they inheriting? And they can tell by where they're placed in the probate petition whether they're healthy or a minor or disabled. Okay? Why put that out there in the public realm in this day and age with identity theft and fraud and so forth? Okay? You want to keep things private. In addition, in this realm, a child is called a distributee. If you are treating your children differently in any way as far as inheritances, either disinheriting and cutting out entirely or different percentages, doesn't matter to the court. The court will require every child to sign off on that probate proceeding, on that will, before it's admitted to probate. So if you have in fact disinherited your child, perhaps they're somewhere in Florida, I haven't seen them in a couple of years, and that child is inheriting nothing. Do you think they're signing off on the court papers to make things go faster for the rest of the family? They're not. They can hire their own lawyer and they can gum up the works for a good couple of years and for a good $10,000, $20,000, $30,000 in legal fees. So again, other concerns and challenges you want to avoid. Another great reason to avoid probate is if you have real estate outside of New York. Not talking financial accounts, just speaking about real estate. If you have your home in Florida and you have a home here in New York, if you pass away and that home in Florida is in your name alone or your loved one's name alone, you're looking at a probate proceeding to get started in New York, and then it gets finished up in Florida. Okay, so if you have real estate outside of New York, that is a 2 probate proceeding problem. Okay, you want to make sure you avoid probate. Again, joint accounts with survivorship. You want to make sure you got beneficiaries on certain accounts like life insurance or retirement accounts, annuities, and finally, trusts also avoid probate, which is why we're here talking today. Court backlog and closure. Yes, I started or created this slide back over the last 2 years during the pandemic. If you go back to the summer of 2020, and there was backlogs all the way through 21, but the courts were closed for several months. Significant problem. Not only that, we had the unfortunate reality of many, many, many more people passing away during that time, and the courts weren't working. They weren't operating. Significant delays and backlog that, again, you don't want your family to have to endure. Another very key point is as our loved ones are getting older, if they are on Medicaid benefits and Medicaid, the New York State program, is paying for their care, if they pass away with something owned in their name alone, you have to go through probate. And guess what? In New York State, they can get paid back from whatever is going through your estate. It's called Medicaid estate recovery. So if a person has $10,000 in a bank account in their own name, which is a reality for some people on Medicaid because you're allowed 16, or even their primary residence. See, that's interesting about Medicaid. They let you keep your home. We don't ever want you to have your home in your name if you're applying for Medicaid, but some families don't realize that, and they do it without competent elder care attorneys, and they leave the house in their name. If you're on Medicaid for a couple of years and then pass on with that house in your name, guess what? You're going through probate. In New York, Medicaid is getting paid back. All right. We have a family right now where that exact scenario happened. It is over $300,000 gone, gone. All right, because they went through probate and never moved the property out, and we're dealing with it now on the back end. All right. So these are very, very valid reasons to avoid probate. A webinar unto itself one of these days. All right. The fourth and final risk out there, and why we want to use powers of attorney and why we want to use the proper trusts, is because of inheritance issues. The reality is that, as I shared in the intro there, that when parents pass on and they leave assets to the children, a lot of the time it's an outright inheritance. They're just leaving the house, they're leaving the bank account, they're leaving the IRAs, the investments outright for the kids to do what they want once they inherit them. That's okay, but there are risks. All right. And that's what this is about. There's a way to structure an inheritance so that you can protect the inheritance and it doesn't get lost if, God forbid, a child of yours passes away after they inherit it. All right. Let's say they inherit in July, but God forbid they pass away in September. Now what? Where does that money go? Are they married? Does it go to a spouse? Do you have a relationship with the spouse? Does it go to minor children? What happens if that occurs? The next risk is what happens if your child is ill when they inherit? What if they're on Medicaid themselves when they inherit from you? All right. This is a contingency we always deal with in all of our plans, but because it happens. If you have a child that's ill and on Medicaid and then they inherit from you, they're getting kicked off of Medicaid. All right. Perhaps New York State's getting paid back. There's a lot of risks out there. All right. This is a real one for a lot of people. Your child inherits, it's a rocky marriage, or perhaps it comes out of the blue and there's now a divorce. If that money was not properly protected or inherited by that spouse, that child, it's certainly subject to a claim of equitable distribution by the divorcing spouse. Okay, so you can protect against that in a right and proper way. Addiction issues. Listen, I've been sitting with families for 24 years. Almost every family has something, very, very literally. And I even venture to bet every family has something. They may just not talk about it as freely as others. Addiction is a real concern. Spendthrift issues, which I'll mention, of course, a legitimate concern. So we don't want the money being misspent, okay? And we don't want it going to people that perhaps are going to make the wrong choices or spend it on the wrong items, all right? There can be creditor financial concerns. We sit with clients where, of course, the parents, they're financially sound, but the child may have a bankruptcy. The child may have in the middle of a foreclosure, or creditors coming after them for school loans. You want to be mindful as to where the inheritance is landing and how is it getting there, okay? And trusts can help with that. Final concern, as I mentioned a moment ago, is spendthrift. That means somebody that will take the money in and spend it unwisely. All right. You want a gatekeeper for a lot of people, especially if these concerns occur. And you want the inheritance perhaps to be placed in trust so that if there is a spendthrift and they're getting $100,000, you want to make sure they're not buying the new Corvette, right? That wouldn't be a prudent expense if that's a windfall for them in their life. So you want to make sure that there's a gatekeeper, a trustee, if you will, overseeing how that money is spent. All right. Again, very legitimate concerns and things we see every day of the week with our clients. So, surprise slide here. What are our options to protect? How do we do it? Well, certainly trusts. There's what's called revocable trusts. How are we doing on time? There's revocable trusts. There are irrevocable trusts. We'll talk about them a little bit. Powers of attorney. We'll talk about it a little bit. It is through this power of attorney, like I shared earlier, where you can name somebody to handle your affairs. So if you don't protect your assets, or you didn't do it properly, or if you have to add something or change something, the power of attorney can do it for you. All right. But let's talk about trust first. So a trust, as I've shared many times before, again, in those prior webinars on our website and on our YouTube channel, a trust is not something to be intimidated by. When I sit with folks, I do simply ask, have you been involved with trust before? And sometimes a family will say, sure, my dad had a trust for us, and they're familiar with the intricacies a little bit. Most people haven't seen a trust. It just sounds like something for the Rockefellers and the Vanderbilts. It is not, I assure you. We have properly set up trusts, revocable and irrevocable, for folks with a house and 25,000 in the bank. Okay, a trust is nothing more than a written agreement. All right, between two people, generally speaking, but it's a written agreement that says, all right, trustee, I am giving you to hold X, my house, my bank account. Okay, you're going to hold that for me while I am alive and healthy, and you're going to use it this way while I'm alive and healthy. And if I'm alive but not healthy, you're going to use it this way. And then ultimately, when I'm gone, distribute whatever's in that trust to the following people in this way, right? We just spoke about inheritance issues. It could be an outright inheritance. It could be an inheritance in further trust to protect against those list of things we just spoke about. All right, so it's just a written agreement that details the management, use, and ultimate distribution of what the trust owns, okay? Every trust has to have four parts. A trust has to have a grantor, all right? That is the creator of the trust. That is the person granting it, okay? You have to have a trustee. That's the manager. You have to have a beneficiary. There are different types of beneficiaries. You can have lifetime beneficiaries. You can have what are called death beneficiaries. You can have income beneficiaries that are beneficiaries of any income generated, and you can have principal beneficiaries, all right, which is a beneficiary of what's inside the trust. So that's where it gets a little technical, but that's how you build a trust. Last but not least, a trust needs to have something in it. If you've ever seen a trust document, it should have what's called a Schedule A, which is the last page. And that is an informal listing of what the trust owns. Sometimes you'll just see $10, okay? That is a symbolic deposit because the trust has to have something to govern, okay? For other families, it's going to be the house. For other people, it's millions of dollars, all right? It depends on the family circumstances and the assets. Now, two different types of trusts. You have what is called a revocable trust, and you have an irrevocable trust. They serve different purposes. They have different names, so they mean different things, right? At the end of the day, a trust is about control and access, okay? If you have control and have access, then it's a certain type of trust. If you have limited control and limited access, then you're going after different goals, different objectives, and you'd have the other type of trust, all right? And I'm going to talk about that now. So, two types of trusts, revocable and irrevocable. They are primarily done for two different purposes, okay? The first purpose is avoiding probate, which is a huge issue, as I mentioned earlier, as well as asset protection, okay? So again, two types of trusts, revocable and irrevocable. Goals and purposes are probate avoidance and asset protection. On the last slide, I shared that it's about control and access, right? So in a revocable trust, because it's revocable and I set it up, I will have all of the control and I will have all of the access, all right? In an irrevocable trust, I'm setting it up for different purposes, which means I'm going to intentionally limit my control and limit my access so that I can gain protection, all right? So look at this. A revocable trust can own your home, can own your investments, can own your bank accounts. And since it is a trust, like I shared way back in the beginning, it will avoid probate. Okay, so if you transfer an asset or an account into a trust, it will avoid probate when you pass away. Now, that's regardless of revocable or irrevocable. An irrevocable trust also avoids probate. But because in an irrevocable setting, we are limiting control and limiting access, not entirely eliminating it, we're just limiting it. Irrevocable trust has a tremendous amount of control and flexibility, but we have to limit control and limit access in order to gain asset protection. Okay. Now, because the revocable trust, the one on the top there, has unfettered control and access, it does not provide any asset protection whatsoever. In a revocable trust setting, I can set the trust up on a Monday, put assets in it on a Tuesday, amend it on a Wednesday, pull assets out on a Thursday, and revoke the whole darn thing on a Friday. So because I have all of that control and all of that access, there's no protection, okay? But let's talk more about protection and the irrevocable trust. That's what we're here to do. Now, an irrevocable asset protection trust, we work with them every day of the week. I can guarantee you, you know somebody that has one or is putting one together, all right? They're that common. They're typically done in the context of planning for long-term care as we get older. It's very important to realize this first point. When you are setting up an irrevocable asset protection trust, Medicaid, which again, this is not a webinar about Medicaid. We'll do one in the future, or you can go to our website to Tully Elder Law to look at a Medicaid qualifying webinar as far as what are the particulars. But for our purposes today, Medicaid eligibility has what's called a look back. And the look back is a period of time in which the Medicaid agency will look back and see what has happened with the assets. How did this person become eligible? In a nursing home setting, we're looking at a 60-month look back, 5 years worth. In home care, pretend the 30 is not there right now. In a home care setting, there is no look back at all, no look back whatsoever. New York State has on the books, however, a new 30-month look back for home care. It hasn't been implemented yet due to the pandemic and what's called the public health emergency. New York cannot make Medicaid more complicated, more difficult to be eligible for during the pandemic, during the public health emergency. So come April, when President Biden and they decide whether they're going to extend the public health emergency, perhaps New York State will start a 30-month look back for home care this year. We just don't know yet, all right? Bottom line is you want to set up your irrevocable asset protection trust, then go live your life for 5 years, because that's the longest potential look back period. And hopefully you don't need long-term care until after that point, okay? Now, the most important point when it comes to an irrevocable asset protection trust, like I've said several times already, we need to limit access and we need to limit control. If you have access and if you have control, then so does Medicaid, okay? So whatever's inside the trust is what's called principal. That is the house, or that is the bank account, the investment account. That is the principal. That principal can never be distributed directly to you or be used for your benefit, all right? Once it's in the trust, it stays there, or we build in a back door for the kids. But the reality is an asset protection trust has to limit access and control, and this is how we do it, all right? Again, there's ways to get it out if necessary through children. Income. If there is income generated within the trust, that can in fact go back to the grantor creator of the trust, okay? So if you're living on that income, you put the asset in the trust, you're still going to get it. The trust very clearly says also that the grantor creators, mom and dad, husband and wife, spouse, have the right to live in that house for the rest of their life, okay? Because they have the right to live in that house for the rest of their lives, the next point is very important. You keep any real estate tax exemptions, all right? So if you have senior citizens, if you have a star, enhanced star, veterans, you do not lose your real estate tax exemptions when you place your home, your primary residence, into a trust like this. Talking about control and flexibility, you can always sell the house with the trustee. You're not locked into living there for the rest of your life. In addition, that trustee can then buy another property for you. A lot of flexibility there, okay? Um, More flexibility in an irrevocable trust. You are not the trustee. You pick a child or children to be your trustee, but you reserve the right to remove that trustee. So, in other words, if you need to, you can actually fire your child as the trustee. And every time I say that, the parents always laugh more than the kids. But it's true. You know, we want our clients to have as much control and as much security as possible. And by the parent, by the client being able to remove a trustee if there's tension or conflict, it gives them that security. Now, with beneficiaries, it's the same thing. The client can remove or change or add beneficiaries. So if there are 3 children involved and one, unfortunately, there's a falling out, they're no longer involved with the family, that child can be disinherited, even though it's an irrevocable trust. Okay. Or on a good note, if you want to include the grandchildren, you can rewrite that section, even though it's irrevocable, and put the grandkids in for a percentage. All right. Again, control and some good flexibility. We always recommend what's called a trust protector. A trust protector came around in our world about 10, 12 years ago. It's where you're able to appoint somebody outside the family that can actually modify the substantive terms of the trust if need be. The example I give is you're setting this trust up for Medicaid in New York down the road, but if New York all of a sudden comes out with a law that says any trust that has ABC is no longer an asset protection trust, the first argument is that older trust would be grandfathered in. The second argument would be, well, that's okay because we're going to amend the trust by the trust protector. Again, builds in flexibility. Last point, or second to last point, is this type of a trust, as I share with clients, is tax neutral. Okay, nothing is going to change tax-wise. Your real estate taxes remain the same. You pay income tax on any income generated in the trust or income paid out to you. So the income tax stays the same as if you owned the account yourself. Also, capital gains taxes. All right. So if you sell the house in the trust, you keep your capital gains tax exemption. Upon your passing, the children will inherit the home with a step up in basis, just like they do now without the trust. Okay. If you have any questions about these issues, you can definitely put the question in the chat box or the Q&A, and I'll try to get to it when we're done. Okay. Last point on the trust, it's revocable. It's an irrevocable trust, but New York does have a law that says if everybody involved agrees, we can do away with it. All right. And this is what happens sometimes if we set up the irrevocable trust with that 5-year look back in mind, but we believe and we know that dad can stay home and not go to a nursing home for 5 years, but then things change and he can't. All right. So if we have to deal with the trust within the 5 years, we can always revoke it if necessary. Okay. Not always a simple process, but it's usually doable. Now, I've had clients say, well, okay, I'm dealing with this with a client right now. Why don't we just give the house to the kids? Well, you want to be careful. I call it the D's. Okay. You do not want to make outright gifts of all of your money, of all of your assets. Can you give $5,000 to a child who's getting married? Yes. But do I want 100 grand going there? Do I want the house going to a child? Absolutely not. Why? Kind of like those beneficiary issues I mentioned earlier. What happens if that child is owning your house because you decided to give it to them and they die? Who owns it now? Their minor kids? The daughter-in-law, the son-in-law that you don't get along with? Are they kicking you out of the house? Maybe. All right. So an outright gift is a risk because what happens if the child passes? What happens if the child is ill and they need Medicaid themselves and they have your money? What happens if that child goes through a divorce holding your asset while you're 100 grand while you're still alive? What happens if there's an addiction, like I shared earlier, or if there's drugs? I mean, I'm trying to stick with the D motif here. What if there's financial debt? What if that child is dishonest and does something wrong with it? Taxes, or D for duty, you know what I'm getting at. And finally, what if they just do something dumb? What if they're holding your 100 grand and they do something dumb with it? If they gamble it, if they do the bathroom, if they go on a cruise, you lose control when you give assets to a child. If you use a trust, that is a neutral entity that can hold the property. Okay, trust is hands down a better way to go. So, other than an irrevocable trust, how else can we protect? What other tools can we use to protect our pot of gold? Well, it's going to be the power of attorney, and you knew that was coming, and that's why you're here. The power of attorney is, in my opinion, the most important basic estate planning document that exists. And I say basic because every adult, whether you've got $100,000 to your name or $100 million to your name, every adult has to have a basic plan in place, which is your will, which is a power of attorney, very comprehensive one, which is a healthcare proxy and a living will. Out of those four, the power of attorney is the most important. Okay, it's where you're appointing somebody to make all legal and financial decisions for yourself. Do not use the internet forms. Don't do LegalZoom. Don't do Susie Ormond. That's my opinion. All right. Those forms, in my opinion, do not cover all the appropriate language and requirements that an attorney can build that form to include. Do not use a simplified form. I even say on some occasions, there's all I practice is elder law. All I practice is estate planning. That is it. I am not a bankruptcy attorney. I'm not a divorce attorney. I'm not a real estate attorney. If one of those attorneys start trying to do elder work and planning work, I think there's risks. Just like if I start doing a divorce for somebody or a bankruptcy proceeding. I don't know what I don't know. All right. So you want to be careful who you work with to get the right planning documents in place. Okay. Power of attorney, currently, it's been a confusing history here in New York. It's changed 3 times. New York State has changed the statutory form 3 times since 2009. 2009, 2010, and again last year. Okay, so you want to make sure that if you're signing a new power of attorney, it is the statutory short form, as they call it. It is durable, and it is the June 2021 form. In addition, you want to, and this is the most important, you want to make sure that that power of attorney has the correct modifications built into it. When they updated the form last year, they simplified it, believe it or not. They were attempting to simplify the power of attorney. There is a modification section that says, I can add other language here, and it says it's optional. Once or twice a week, I'm looking at a power of attorney with that optional modification section blank. That means there is no asset protection or income protection or Medicaid powers built into the power of attorney. The form, as New York State created it, is for everyday things. It's not for aging. It's not for elder care. It's not for protecting the house or the income. You need to add that language in. Okay, I can't stress this enough. The correct modifications and the correct power of attorney form, worth its weight in gold, no pun intended for today. You need to make sure it's executed properly. The way you do that is make sure you have an experienced attorney helping you sign it appropriately, initial in the right boxes. You need to pick a trusted agent. You need to have successors. You do not pick a power of attorney agent just because they're the son. You do not pick a power of attorney agent just because they're the oldest. Okay, you got to pick the right one that has the right financial head and responsibility and discipline to be able to handle these issues. Okay, and you always have a backup. You don't just do one, because as we know, things can happen. If it's done correctly, the power of attorney will avoid guardianship, and it allows for the asset and income protection that we've been talking about. Okay, so almost done. We have options to protect. Okay, the timing is crucial. When are you going to protect? Are you going to set the protection up in advance, or are you going to wait for a crisis to occur? That's it. You do it in advance, or you don't do it until the crisis occurs. Those are your options. Guess which one I want you to do? I want you to do it in advance. Not only in advance, I want you to do it as soon as you can. Asset protection is generally for folks 65 and above. Okay, not everybody, but generally 65 and above is that irrevocable trust plan that I'll talk about next. Power of attorney, every adult, as I've said. My 2 kids in college have it. If you wait for a crisis, the crisis will always be more stressful. The crisis will always cost you more. The crisis will always give you less options. You don't want to wait till a crisis. I mean, simple analogy, but running out of gas on the parkway, right? Is it stressful? You better believe it. Do you have limited options? Yeah, you can only work with a certain tow truck company that's going to charge an arm and a leg, right? Is it going to cost more? You better believe it. All right. Long-term care, a little more complicated, but it is still a crisis and the same concepts apply. So when should I start to protect your assets? It's now. All right. If you're over 65 and you're listening to this, please give us a call, free consultations. You meet with me directly and we'll go through this as it pertains to you. Okay. When we do this for 65 and older, it's what we call an elder care protection plan. It's not just an irrevocable trust. We work with families and build plans. We're here to help them literally for the rest of their lives. This is how we plan on it, okay? This is the relationship. This is the services we build. Our elder care protection plan includes the basics, even though they're not basic documents, it is a basic plan. So it's the last will and testament. It is that very crucial, durable, modified power of attorney. It is the healthcare proxy. It is the living will, which is the end of life document. Again, I didn't get into the healthcare today. Surprise, our webinar page on our website has more, but it also includes that irrevocable asset protection trust. Okay, when we help a family with an elder care protection plan, we stay on board for a year. Questions, no problem, no cost. Changes, no problem, no cost. We have meetings throughout the year so that we make sure everybody stays on board. Okay. When we meet with families, all right, there's three things that this office, that my firm is driven by. We approach the legal, the financial, and the care domains of aging with three goals: protect the assets, get Medicaid to pay for the care, and help your loved one get the best care possible. All right. Not many law firms can say this. We're very unique and very special in that regard. A typical elder law firm is going to handle the legal and the financial. Yeah, they'll do the documents. Yes, they could protect the house. Yes, they could get Medicaid to pay. But the care, you're on your own. All right. When we come on board to assist, assuming it's time for care needs, right? We're looking at Medicaid needs. We provide a service, not the elder care protection planning, because that's for younger and healthier, but life care planning. That is the service where we incorporate the care advocacy, the coordination, the crisis intervention with my advocates. I've got geriatric social workers on staff. I have a geriatric RN on staff, all to help our families and their caregivers through the aging journey, okay? Yes, we'll put together the asset protection trusts. Yes, we'll make sure you have that comprehensive, durable power of attorney, but it's all a part, all right, as we get older with the elder care protection plan or the life care plan, all right? If you have any questions, okay, I'm here personally. You can schedule a free consultation. You can ask your questions now in the Q&A box or the chat. We're here to help, all right? Brian at Tully Elder Law is my direct email. I spell it, I'll say it the Irish way, with an I, B-R-I-A-N, at Tully Elder Law, TULLYELDERLAW.com. I remember once I spelt out .com and one of my kids reminded me that that people know how to spell com. Anyway, let me see if we have any questions, and I look forward to meeting you in person at some point. All right. Do we have expertise in special needs trusts? Yes. Special needs planning is estate planning, and we build in contingencies that deal with a potential disability in the future, but we also work on what are called first-party supplemental needs trusts, as well as third-party supplemental needs, or as you're quoting it, as a special needs trust, same thing. We certainly do help with that, and we'd be happy to help you. Any other questions, folks? Come on. I've been told I'm good. I just don't know if I'm that good. 62. Is 62 years of age too early to plan? So, Mary Ellen, it depends what you're planning for. Every adult should have an estate plan in place. As far as the elder care protection plan, generally speaking, it's 65 and above. If you're 62 and you want the protection done because you're a planner and you want it done, yeah, you can get it done at 62. 100%. Okay. All right. No more questions, folks. Feel free to follow up with me if there's anything you'd like to ask. Grateful to be here. Oh, wait, another question. What if a trustee doesn't administer a trust correctly? Who can bring an action to help? In particular, the question is about special needs. That is a good question. So there could be what are called residuary beneficiaries, right? Typically, a special needs trust is in existence for the beneficiary's life, and then it passes on to the remaining children if those do exist. If that remaining child is the trustee, then you kind of have a problem. Oftentimes agencies are involved, but you're right. It is a concern moving down the road. Can you choose a non-family member as a trustee? You can always do that. We do generally like to have the family involved, assuming they're trustworthy, assuming that, no pun intended, assuming that they're responsible. Local isn't necessary, but it's nice. Can you choose somebody outside the family to be trustee? You can. You can choose a sibling, you can choose a cousin, a niece, a nephew, an accountant, generally not, excuse me, generally not a financial advisor. You could choose an attorney. And some firms and some attorneys do that and some don't. It depends. Okay. All right. Do a copy. Yes, there will be a copy of this. We have it again on our website starting, I think it'll be up there by tomorrow. All right. So a copy of this webinar will be on our website, tullyelderlaw.com, hopefully by the end of business tomorrow. Okay. If you don't see it up there, shoot me an email and I'll make sure you get it, but it should be up there by tomorrow. Thank you again, everybody. Please get on our email list if you're not, so that you can get notice of these as we move forward. Thank you very much. Wait, another question. Hold on. Excuse me. Let me get a sip of water. Can an adult child move an elderly parent's home into an irrevocable trust to avoid probate? So, Clifton, if the parent has capacity, they should do it themselves. If the parent doesn't have capacity, that's what today's all about. That's where the power of attorney comes into play. As long as that power of attorney has, excuse me, folks, as long as that power of attorney has the modifications to allow the creation and funding of an irrevocable trust, yes, that can be done. The purpose of the irrevocable trust is twofold: to protect against future long-term care costs and protect against Medicaid, like you mentioned in the question. All right, that's it. All right, thank you, folks. All right, have a great day. Enjoy spring. I hope I just didn't jinx it. And we will see you around. Bye. You're welcome.